Disclaimer: I am a law student, and the legal information provided is not legal advice. For that, please hire an attorney. All right, the last thing I want to talk about, and I'm not sure how formal this has to be. The last thing that I want to talk about is, I keep forgetting how to pronounce his name. Ahmaud Arbery. All right. So earlier, and mind you, I was not preparing to necessarily do this. This is actually a very on the spot. So I don't know if this will get made into a video, but I definitely had thoughts, and actually this was very pertinent to the discussion. Like I think that I can contribute a decent amount of conversation to this subject because it is a lot more nuanced, right? It's a lot more nuanced, and like it's a very kind of touchy subject with a lot of people, but like I can approach this at least from the lens of someone who just took criminal law and talk about like the relevance of a lot of recent discussion. I'm going to give a caveat here that I am basing what I'm talking about on the information in Vosh's video. All right. If I misrepresent anything, then I don't know, blame him. I'm just going off of what he said in his video as far as like information for me to be able to talk about, right? So to summarize, right, at least to the furthest extent that I understand it, you had a man named Ahmaud Arbery. He's a black guy. He lived in the neighborhood and he frequented that neighborhood. There was a abandoned premise where people originally said that he had allegedly frequented and had possibly stolen something from. There was a group of a couple guys who got together and drove around and looked for Ahmaud Arbery after suspecting vaguely that he stole something without any evidence that they produced at the time. They just sort of thought it was him. And after finding him on the street, they murdered him. Specifically, two of the people did, like 2 men, and then one person who was recording. Which is not great. It's really, really not. I'm about to talk a little bit about the law, or at least what I learned in my criminal law class. As I have said before on my channel, I have to be very careful because while I know the law, I am not bar certified, and I have to make sure that I do not give any legal advice or come to any legal conclusions. The way that I am able to do this is by talking purely from the perspective with the heavy caveat that I'm only talking about what I learned in my class, and I'm only speaking in the abstract, hypothetically. So the only other fact that I'm going to talk about with the Ahmaud Arbery case is the fact that apparently a lot of people have been making videos, a lot of very far-right creators, like Tim Pool, Catholic Hangout. Also, if anyone knows anything about that, like, please tell me. I have no fucking clue. And other people like that, right? I think The Quartering made a video about the fact that there's now released video footage of Ahmaud Arbery having gone into these various abandoned premises on like multiple prior occasions, right? This was not necessarily produced at the initial sort of discovery process, but was discovered later. That's all I'm going to talk about, the specific facts related to there. Now we're going to talk hypothetically, and we're going to talk about what I learned in class, and we're going to have a little story time. So this is my outline from criminal law. It has everything that I learned in the entire class. It's tabbed very, very nicely. I'm very proud of it, actually. And I'm going to tell you all a little story, and the story is called What I Learned About the Common Law Elements of Murder. The common law elements of murder and involuntary manslaughter are 1. The unlawful. 2. Killing. 3. Of another. With malice of forethought. All right? I'll repeat that again just so that we're all clear, all right? It's a very, very simple definition. It's the unlawful killing of another with malice of forethought. Malice of forethought is a little bit of a term of art. It has a lot of different possible meanings. Here are some of them. It can mean that you act with the intent to kill a person other than the victim, which would be transferred intent. You act with the knowledge that what you do would kill your victim. You act with the intent to inflict grievous bodily harm to your victim. You act with the knowledge that he would inflict grievous bodily harm, or that you would inflict grievous bodily harm, or that you act with a depraved heart, or just an extreme indifference to human life, such that you well should have known that what you were going to do would have killed someone. Or felony murder, which is to say that you had the other elements and you did all those elements in the course of committing a felony, like armed robbery. Murder is really sort of black and white at the end of it. So here are some interesting insights about it. If you have a police officer, and the police officer is not on duty, but ends up killing someone, that's murder. Because it's not a lawful killing of someone. They're not on duty, and they're only allowed to take someone's life, other defenses absent, if they are on duty. Let's say that you walk into an office. This is a much more extreme example, but I remember this from my semester, so I'm just going to talk about it a little bit. Let's say that you walk into your office and you're just finished with your office. You're finished with your job. And let's say that you bring a gun with you and you start waving it around and you're just about to have a mental break and be like, all right, everyone, don't make me do anything crazy. You don't have any necessary plans, but you're bringing a gun into there. And let's say that while you're waving your gun up in the air, you end up pulling the trigger and shooting someone on the floor above you. That's probably still murder. Because even if you didn't act with the intention of killing a specific person, you probably acted with a depraved heart. Let's talk about a very unfortunate example. This was actually, I believe, an example from a case that we read about. Let's say that you had a kid. And let's say that this kid is going to a high school dance with his friends. And let's say that this kid wants to show everyone that he's super cool, all right? That he's just a really edgy kid. I don't know, let's say this is middle school even, where the kids are super edgy, right? So he decides to bring a gun with him. And he goes into the guy's bathroom with all of his guy pals, and they maybe had a bit to drink. Maybe they snuck in some alcohol. And they start playing with the gun. And let's say that this kid, in the course of handling this gun, even though he never meant to hurt anyone, ends up accidentally pulling the trigger and shooting someone and killing them. If a prosecutor wanted to be really mean to that kid, you could probably charge him, hypothetically, with murder. So, speaking hypothetically, if you had 3 guys who were just going around and hypothetically looking for some black guy who they think stole from them, but didn't otherwise have any evidence to do so, and then those 3 people found a random black person and decided to kill him in the street without any authority to do so, that's murder. Hypothetically speaking. Hypothetically. Now let's say, hypothetically, that these 3 people then tried to claim some sort of defense, right? Let's say, we were justified in doing what we did. We had reason to do this. We were totally... Well, Something else that I learned about in my criminal law class is that there are a very specific subset of justification defenses to be able to use to, if not get entirely out of a murder claim, charge, if not to be able to get entirely out of a murder charge, to at least be able to reduce the sentence or reduce the severity of the charge against you. The first place to start, and this isn't exactly a justification defense per se, but it's more just trying to get it mitigated entirely, is to try and argue a defense or argue that actually you acted involuntarily in the act of involuntary manslaughter. That has the same basic three elements: an unlawful killing of another with malice aforethought. But what's important to recognize is that the difference is that involuntary manslaughter is not murder alongside malice aforethought, right? It has a different mens rea. It has the intention, or it rather is to act with such a mental capacity as, let's say that you are acting with such a very, very outlandish emotional motivation that you acted in a reasonable way compared to how any other person would have acted in the same circumstance. Some examples that people try to use in order, like in these types of cases, is like, and again, like this is terrible, but this is like an example of how this gets brought up in court. Let's say that you have, I don't know whether to make this a husband or a wife. It doesn't really matter either way, but I know that there are like different narratives that can be spun with each. So let's just say a wife. All right. Let's say that a wife comes home. Oh, there are a couple different ways. All right, I'm going to go through a couple different hypotheticals. So the first hypothetical is that like a wife comes home, she's married to a husband, and she comes home and she sees that the husband is sleeping with another woman. She freaks the fuck out, gets like a knife or a gun, and kills both of them. There might be a good chance that she could say, Your Honor, I didn't act with malice aforethought. I was just like I know that what I did was wrong in killing them, but I also know that like I was acting under like such an extreme emotional stimulus that I acted the way that any other reasonable person would. There's a good argument that she could get her charge reduced to involuntary manslaughter. Another example where this is normally brought up, unfortunately, and trigger warning, content warning, abuse. This unfortunately comes up a lot in instances where you have spouses, especially wives, who are abused by their husbands and who are regularly subjected to physical abuse and emotional abuse. And they aren't really able to do anything to get out of their circumstances except for to kill their husbands. These are particularly troubling kinds of circumstances. They're really, really not great. And they're hard because like judges want to sympathize with these people, but ultimately they still took a life. And so the law kind of ties their hands. It's really sad. That's involuntary manslaughter. All right. And then beyond that, there are a couple very specific justification defenses. That's where you say, I know what I did was wrong, but I had a valid reason for doing so. The first is necessity and self-defense. All right? Necessity is where it has a lot of elements, all right? But as I learned about it in my criminal law class, necessity can provide a full defense in circumstances where a defendant's crime is reasonably calculated to prevent an imminent greater harm, and can provide a full defense where, and this is a lot, so stay with me, 1, by virtue of all the circumstances. 2, not a defendant's intentional, knowing, or reckless creation. 3, there is an immediate, and 4, emerging threat. 5, of significant harm. And 6, defendant commits a crime. 7, that is reasonably likely to prevent harm. And 8, the harm caused by his crime is substantially less than the harm prevented. And 9, the defendant had no lawful or reasonable alternative. 10, of which he was or should have been aware. then you can commit a crime. The standard example of this is like the trolley example. All right, if anyone has taken a philosophy class on like the trolley example, a great example is like, let's say that you were like, just to go over the example, right, for people who aren't aware, let's say that you're next to a trolley, all right, and you see that the trolley is coming, and that if you let it keep going, then like if it keeps going on the track that it's on, then it'll kill one person. But if you pull, or that'll kill 10 people, all right, if it keeps going on the track that's going, then it'll kill 10 people. All right, you are able to pull a lever. But if you pull the lever, then it's going to change the trolley onto a different track where it's going to kill one person. All right, this is an example where at least the law is going to say, hypothetically, according to this hypothetical, we're all speaking hypothetically here, we're just talking about what I learned in my class. The law would say that you are able to pull that lever. Because even though technically what you're doing is an action which is going to result in someone's life dying, at least someone different from who was initially intended, there wasn't really any alternative given to you, or at least none that you reasonably knew about in the circumstances, and you were able to save more lives than you ended. That's an example of that sort of defense. Self-defense is a special case of necessity that covers the use of deadly force against a person engaged in an unlawful use of force that threatens the life of another. The elements of a common law excuse of self-defense are where 1. The defendant actually, 2. and reasonably believes that the victim is in or is threatening to engage in, 3. the unlawful, 4. use of force, 5. that poses a risk of death or severe bodily harm to the defendant or a third party, 6. that it's imminent, 7. the defendant did not initiate the confrontation with the victim, 8. the defendant uses force, that is 9. reasonable, and 10. necessary to terminate the threat, and 11. there is no reasonable opportunity to escape or defendant was not aware of a reasonable opportunity to escape. So let's be clear. An example of this would be where if you, and again, like the morale, like we're not talking about necessarily what's morally just in the circumstance. We're talking about what the law says. Let's say that you are walking down the street and someone comes up to you and pulls a knife, all right, and is like, I'm going to knife you if you don't give me all of your money. And then you, being the Rudy Tootin'est cowboy in Texas that you are, pull out a John Hancock handgun and say, not today, motherfucker, and shoot the person. There's a good chance that this person in this hypothetical would probably be able to use the defense of self-defense. Now, let's return to our hypothetical earlier, with the 3 men who hypothetically surrounded the 1 black man in the street. Do any of these excuses apply? Probably not, especially since we know that the man was not armed. They had no reason to reasonably believe that he was armed. Again, reasonable being an objective term, not subjective. It doesn't matter necessarily what they thought, but whether what they had believed was reasonable. All right? And otherwise, he was just a guy walking down the street. It's still, at this point, murder. Let's go on. There are a couple other excuse defenses. These are all having to do with your state of mind. Probably not as relevant for discussion, but they include duress, entrapment, and intoxication. We won't include them specifically because in the hypothetical from earlier, it doesn't seem like there was really any room to include any of these. It's not like the people who murdered this man were under duress, were being forced to by some other third party under like threat of death. It's not like they were being forced to by the government. It's not like they were intoxicated when they were doing so. The last couple excuse defenses are mental disease or defect, otherwise known as insanity. And as far as I'm aware, from the construction of my hypothetical, which is entirely hypothetical and has nothing to do with the real world, bar review committee, please be kind to me. as far as we are aware, the people who were in that act, the people who committed that murder, were not under any kind of mental disease or defect at the time. Maybe further evidence will reveal otherwise, but at this point, I'm not aware of anything. Here's a question. Now that we've gone through the main excuse or justification defenses that you can introduce with a claim against a claim of murder, let's say that the hypothetical earlier also included the fact that the person who was murdered ended up trespassing onto certain premises at multiple times in the past, although not at the time that he was killed. Well, I think that the place that some people might try to go, if we're talking in the hypothetical sense, I need to get like a hat that, listen, someday if I get merch, I'll get merch that says like disclaimer on it. Put like disclaimer giant over like my titties. That'd be great. Some people might think of going to the defense of stand your ground, which is a law that currently exists in a lot of states, which goes to the effect of if someone trespasses onto your property, again, like I'm not going to go, like we learned about this in my criminal law class, but like this varies a lot state to state. So I would recommend checking with your, local state's laws. But in a lot of states, you might be able to execute a defense of self-defense, and especially using deadly force if someone trespasses onto your property. This goes to like the castle doctrine. But as far as I am aware, and again, like check your state, but really this only applies while someone is on your property. And once they are off of it, you don't have the authority to use deadly force anymore. So, and again, check your local laws. As far as I am aware, there's no exception for that. No one's really going to care once they're off once they're off your lawn, right? They're on the sidewalk. People have the right to protest or be on sidewalks. I'd like to think that I'm not going to be shot for being on a sidewalk, but we live in a society where apparently that fucking happens. So yeah. It's really interesting to me if we're still operating in this hypothetical universe where people want to introduce the fact that this hypothetical person was continuously trespassing onto the property, or like at least in a couple occasions trespassing onto the property of these people. It's really interesting to me because the fact of the matter is, this is completely irrelevant to the claim of murder. It has nothing to do with it. And really, the only purpose that it serves is to try and introduce some kind of bias or some kind of discredibility or trying to prejudice the people who would be the trier of facts, like assumedly a jury, against this person who was murdered. This is literally the primary example of blaming the victim. Like, I do not want to emphasize this enough. This is literally blaming the victim. Okay? I cannot understate that enough. And it surprises me to no end that people think it's justifiable if someone trespasses on your property a handful of times, that you feel like you're able to take their fucking life. If you have a problem, file a police report against them. Get them arrested and press charges for trespass. That's what you do. You don't go out and execute your own justice. That's murder. Which really does make me think that the people who are defending this in this hypothetical universe really just don't like brown people. There are a lot of other places where I wouldn't necessarily say that and necessarily go to that sort of a conclusion, but like, damn, is it very hard to see otherwise here. And it's very disappointing.